Good afternoon, everyone. Thanks for joining us for the latest episode of Kelleher and Holland's Employment Law Lunch and Learn webinars. I'm Amy Rizzo. I'm the marketing manager here, and we have a full menu of topics for you today. Our panelists serving today's specials are Andy Bowling and Madeline Kelleher from our employment law group. And let's just get things started, and I will turn it over to Madeline to get us cooking.
Thanks, Amy. So, good afternoon, everyone. We're here today to discuss some recent changes in federal law that have a huge impact on employment law nationally. On April 23rd of this year, two big decisions were made by both the Federal Trade Commission, commonly known as the FTC, and the Federal Department of Labor. So, first, the Department of Labor updated and revised the regulations issued under the Fair Labor Standards Act, or you might hear us call it the FLSA, by issuing a final rule that expands overtime protections. Briefly, generally, the FLSA establishes minimum wage, overtime pay, record keeping requirements, and child labor standards, and is enforced by the Wage and Hour Division of the United States Department of Labor. But in today's Lunch and Learn, we will be focusing solely on the new federal rule regarding overtime. Second, the FTC issued a final rule to promote competition by banning non-competes nationwide.
Thank you, Madeline, for the introduction into our topics today.
Mhm.
So let's start with the DOL's changes to the overtime exemption rules. What is the FLSA, and what is their definition of an exempt employee?
So, in the overtime context, the FLSA generally requires covered employers to pay employees both minimum wage and for employees who work more than 40 hours a week, overtime pay of at least 1.5 times, so 1.5 times, an employee's regular rate of pay. There are some workers who are classified as exempt from the FLSA overtime pay requirements, including bona fide executive, administrative, professional, outside sales, and computer employees. But today we will be mainly focusing on the executive, administrative, and professional employees. So this exemption will apply when an employee's paid wages, as you can see on your screen, paid wages past the minimum threshold requirement, which is currently $684 per week, and it comes out to $35,568 annually. And the employee primarily performs the requisite duties of the executive, administrative, or professional. As the duties are different for each of executive, administrative, and professional workers, and we'll go through them briefly. As you can see on your screen, executives are exempt from overtime pay requirements under the Fair Labor Standards Act if they meet the minimum compensation threshold requirement. Their primary duty consists of the management of the enterprise or department or subdivision of the enterprise. They customarily and regularly direct the work of two or more employees, and they either have the authority to hire and fire employees, or their recommendations as to hiring, firing, advancement, promotion, or a change of status for the employee are given particular weight. So all of these things you'll see throughout each of the exempt duties and requirements, they all have to apply. The executive has to meet all four of those duty requirements. So then on top of those four duty requirements and, come to the side here, there's an additional overtime exempt option for executives to be automatically considered exempt if the executive owns 20% or more equity interest in the company and is actively engaged in management of the enterprise. So examples of executives that are commonly exempt from the Fair Labor Standards Act overtime requirements include CEOs and other C-suite level employees, mid-level managers, shift managers, and, for example, executive chefs. Next, we'll move on to administrative workers. They are exempt if, first, they meet the minimum compensation threshold requirement. Their primary duty is the performance of office or non-manual work, specifically non-manual work, directly related to management policies or general business operations. And this really truly means the general business operations of the company. So, for example, accounting, marketing, human resources, and the like. And then third, they also must exercise their own discretion and independent judgment with respect to matters of significance. And so they can't just follow well-established techniques and procedures. It has to be really something that they have input in and can choose what they do and how things work at their discretion. So to meet this directly related to management or general business operations requirement, an employee must perform work directly relating to assisting with the running or servicing of the business, as I was briefly discussing. And this is very distinguished, for example, from working on a manufacturing production line or selling a product in a retail or service establishment. And then work directly related to management or general business operations includes, but is not limited to, work in functional areas such as those that are listed on the slide and similar activities. So some examples of commonly exempt administrative workers include human resources managers, in-house accountants, office managers, insurance claim adjusters, and assistants to senior executives or business owners. Next, we'll move on to exempt professionals. So there are two classifications for exempt professionals. They can either be a learned professional or a creative professional. Let's go through learned professional first. To qualify for the learned professional employee exemption, all of the following must be met. They must meet the minimum compensation threshold requirement. Their primary duty must consist of performance of work requiring knowledge of an advanced type in a field of science or learning, customarily acquired by a prolonged course of specialized intellectual instruction and study. And they must consistently exercise discretion and independent judgment. Some examples, as you can see on the screen, of commonly exempt learned professionals include lawyers, teachers, doctors, accountants, pharmacists, and engineers. We'll move on to the creative professional employee exemption. So to qualify for this, they must meet all of the following: the minimum compensation threshold requirement, and the employee's primary duty must be the performance of work requiring invention, imagination, originality, or talent in a recognized field of artistic or creative endeavor. And you can see some commonly exempt creative professionals would include actors, writers, musicians, novelists, cartoonists, certain painters, and soloists, things you would commonly see in a recognized field of artistic or creative endeavor. And additionally, those employees that meet the annual compensation threshold of highly compensated employees are also exempt from overtime pay requirements. Currently, a highly compensated employee is deemed exempt under the Fair Labor Standards Act if the employee earns a total compensation of $107,432 or more, which will include the at least $684 per week paid on a salary or free basis. So the minimum per week has to at least be $684 currently. Next, the primary duty of the employee must include performing office or non-manual work, and the employee has to customarily and regularly perform at least one of the exempt duties or responsibilities that we just went through of an exempt executive, administrative, or professional employee. So, for example, an employee may qualify as an exempt, highly compensated executive if the employee customarily and regularly directs the work of two or more other employees, even though the employee does not meet any of the other requirements in the standard test for exemption as an executive. And that's pretty much a brief overview of the duties and classifications under the Fair Labor Standards Act of overtime.
Perfect, Madeline. So now let's get into what changes were made regarding exemption from overtime pay.
Sure. So as I mentioned, the Department of Labor released a final rule that raises the wage threshold for these certain overtime exemptions under the FLSA. The three significant revisions include increasing the standard wage level, increasing the highly compensated employee total annual compensation threshold, and adding to the regulations a mechanism that will now allow for the timely and efficient updating of the wage and compensation thresholds to reflect earnings growth over the years. So we'll start with the standard wage level. As I mentioned, the current wage threshold for bona fide executive, administrative, and professional employees is $684 per week, which annualizes to $35,568 per year. The new final rule calls for an increase in the threshold to $844 per week, which annualizes to $43,888 per year. So this will start on July of 2024, July 1st, and then it will increase again to adjust again on January 1st, 2025 to $1,128 per week, which comes out to $58,656 per year. Just a quick brief reminder, this is, you do not have to be on salary to be considered exempt. They are looking at it as a weekly wage threshold, not just salary. So I also mentioned previously, moving on to the highly compensated employee, that this wage threshold was currently $107,432 per year, which includes at least $684 per week on a salary or fee basis. And now under the final rule, this threshold will increase to $132,964 per year on July 1st of 2024, which will then, of course, include the $844 per week on a salary or fee basis. And then, same as the regular standard wage level, this for the highly compensated employee wage level, it will also on January 1st, 2025, increase to $151,164 per year, and that will include the $1,128 per week salary or fee basis threshold. And then the automatic threshold updates. So the third thing that I pointed out that of the revisions of the final rule. So of these new wage on top of the wage thresholds, starting July 1st of 2027, the thresholds will update every 3 years by applying up-to-date wage data to determine the new wage levels. Previously, the wage thresholds have been updated seriously randomly since the inception of the Fair Labor Standards Act in 1938, with updates in 1975, then it jumped all the way to 2004, then to 2016 and 2020. So the Department of Labor provided that the purpose of these new 3-year automatic updates is to, and I quote, keep pace with the changes in worker salaries, ensuring that employers can adapt more easily because they'll know when salary updates will happen and how they'll be calculated.
So what about state laws, Madeline? Do these changes override them?
Yes and no. So the Fair Labor Standards Act sets a floor of minimum protections regarding overtime. No state can impose rights that are less than those provided under the Fair Labor Standards Act. However, many states and local governments can legally require more generous treatment to employees. Employers must always follow the law that provides the greatest protection for workers. Many states, counties, and even cities have their own wage and hour laws that they regulate and enforce. Some are similar to the Fair Labor Standards Act, but some differ and are more employee friendly.
So what should employers do now?
So with these changes, employers now must either raise the salaries paid to their exempt employees to maintain the exemption or reclassify their positions to non-exempt and pay them overtime. To do this, employers should perform an internal audit of the current duties and compensation of each of its employees to make sure that they're properly classified as exempt, and then make a decision on how to proceed. We highly recommend that this audit be done with the assistance of an attorney to ensure proper classification, as the consequences of misclassification can be steep. Employers must also consider the pros and cons of reclassifying employees as non-exempt. There are some morale concerns. Why am I being treated as merely hourly now? Am I being demoted? Will reclassification inspire an employee to claim they were misclassified originally as exempt and then be able to claim back pay of overtime? There's also an economic analysis that has to be considered, right? So if the exemption is valid, will the company save money by reclassifying based on potential overtime? Might it might be less expensive in the long run to boost the base compensation. And then consider the option, subject to state law, of the fluctuating workweek method and the possibility in this method of only paying a half time above the regular rate of pay for overtime rather than time and a half.
Okay, so now that we know more about the changes to the wage thresholds for exempt workers, let's move on to our main course, the Federal Trade Commission's ban on non-competes. So Andy, I'll hand it off to you. Let's start off by how the new rule defines a non-compete clause.
Sure, happy to do that, Amy, and good afternoon, friends. Thank you for joining us on our program today. And as before I dive into the contents of my course, I apologize that what we're saying today is going to cause indigestion. I feel like we are serving you some very fiery, spicy chili that's going to leave an unpleasant aftertaste, but that really is, what we have on the menu today. And this was not the chef's choice. Many of my clients, you'll see a picture of a 4-pronged fork on the right side of the slide. But some of my clients kind of view this as the 4th prong of a pitchfork. Because just remember where this all falls, and I'll briefly recap some of our past presentations. We've talked about how you have to really scale back the use of confidentiality provisions in handbooks, NDAs, and release agreements. We've talked about how there's a continued war on the use of independent contractors. And Madeline's got the 3rd point of the pitchfork, talking about these really significant increases in wage levels for overtime. And now the 4th prong is taking away a business's ability to ensure that employees do not misuse customer relationships or confidential information. But that's what we have. It's no surprise. The FTC announced its preliminary rule months ago and recently published their final ruling that will take effect on May 7. And what this does, it defines a non-compete clause broadly, you won't be surprised, as a provision in a contract or employment policy that prohibits a worker from competing, penalizes a worker for competing, or that otherwise functions to prevent a worker from working or seeking work in the United States. So, this is a very, very broad mandate. And the FTC not only defines what is a non-compete clause, but of course they provide some examples that are causing a lot of agitas with the business community. Companies that or agreements that prohibit a worker from competing are those that explicitly prohibit an employee from competing following the end of employment, or agreements that penalize a worker for competing, such as having to pay a penalty or liquidated damages as a condition of seeking employment, and also forfeiture for competition clauses, which may significantly impact the use of clawback provisions in employee equity or other incentive compensation arrangements, which will often reserve the employer's right to claw back realized gains if the employee breaches non-compete obligations. Let's go to the next slide.
So what are the key terms of the final rule banning non-competes, Andy?
Well, the final rule states that the following actions, and I'm going to read through these, constitute unfair methods of competition within the meaning of Section 5 of the FTC. And these include entering into or attempting to enter into a non-compete clause. So much like California, The mere fact of asking someone to sign a non-compete when it's illegal to do so is a separate and distinct violation of law. Taking steps to enforce or attempting to enforce a non-compete clause is unfair competition. And then representing to third parties that a worker is subject to a non-compete clause is also a violation. And so this broad scope essentially invalidates almost all non-compete clauses going forward after the effective date, which would be September 18, 2024, subject to my discussion of some already filed litigation, and would allow for perhaps a limited use of legacy non-competes for senior executives. The rule also imposes some detailed notice obligations to employers. So you have to tell your workforce that if employees have existing non-competes and they don't fall within this limited universe of exempt employees, that their non-competes and other post-employment forfeiture provisions are essentially invalidated.
Andy, can you give us a little insight into the reasoning behind the FTC's decision to ban these non-competes?
Well, the FTC cited a large volume of economic data, essentially stating that in their view, non-competes depress wages, non-competes depress employee mobility. And they estimated, because anytime an agency engages in significant rulemaking, you have to provide some estimations of the potential cost. You may be familiar with environmental regulations where rules may have to state the actual cost to employers for implementing environmental changes. Well, in this case, they believe that this will increase new business formation by 2.7%, and that the average worker will see their wages increase by an average of $524 per year. Let's go to the next slide, Amy.
So when will this rule go into effect?
Technically, September 18, 2024. But there are already 3 cases on file that could very well change this effective date. And for those in the business community who like non-competes, may very well invalidate the entire rule. But we'll talk a little more about that at the end of our program.
And how about the application of this rule? Does it apply to all employees?
Yes, it does. Prospectively, after September 18, you cannot have a non-compete with any employee, whether it's your CEO making a 7-figure salary or whether it's a lowly, first-year manager trainee. However, there is an exemption that talks about special rules for senior executives. It's also interesting that the final rule doesn't use the term employer-employee, and this is intentional. They use the term worker, which is why we are using that term when we talk about the scope of this agreement. A worker can include independent contractors, interns, volunteers, and other types of workers. However, franchisees would probably not be regarded as a worker in the context of an agreement between the franchisee and a franchisor. And also, it's a closer call whether non-compete obligations among equal partners or shareholders would be unenforceable. That's a gray area. And if this rule holds up, there may be additional litigation to clarify these very widespread agreements that introduce not only non-compete, but strong fiduciary rules across members and partners.
Does this rule apply to only future non-competes?
No, except for senior executives, and I'll talk about that in just a second. As of the effective date, almost all existing non-competes are invalidated, including non-competes with someone who may have left your company a year ago, but already has another year to go under the terms of their non-compete. Now, there is a limited exception for senior executives, which require, here, remember all the numbers Madeline threw at you. Here's an important number, that someone earns at least $151,164, which will be the new salary minimum for highly compensated executives as of 2025. And then they must be a chief executive officer or a significant C-level officer and have actual policy making authority. The FTC talks about people who are legitimately within the C-suite. We will see how widespread the senior executive exemption turns out to be. In other countries that have scaled back the use of non-competes, and let's look at the province of Ontario in Canada, which recently eliminated non-competes for all but a limited universe of C-level corporate positions. And even that requires a deep dive into certain C-level positions. So I think that there will be additional litigation. I also like to talk briefly about the compensation that can be used to qualify as a senior executive. It can include salary, commissions, non-discretionary bonuses, and even other non-discretionary compensation earned during the prior year, but it does not include the cost of or employer contributions to fringe benefit programs.
You talked a little bit about exceptions for senior executives. Are there any other exceptions to these prohibitions?
Yes, and I'll talk briefly about two possible industry-wide exemptions. The banks are not within the purview of FTC jurisdiction. So there's a thought that executives within the banking industry may be exempt, but not affiliates of banks. The same is true for a number of tax-exempt nonprofit organizations. They are not within the scope of the FTC. So those industries we'll put aside for right now. But let's go to some more traditional scenarios. It's customary when a business is sold to require the sellers to enter into often extensive 5-year, 10-year non-competes with the buyer. These are not impacted provided it's a bona fide sale. But for those creative types, remember that California, which bans almost all other non-competes, allows a limited exception for sales of business, provided the shareholder who is committing to a non-compete has a substantial stake in the business. So giving someone 1%, 0.5% of equity, thinking I can get a non-compete, probably won't fly.
Are there any alternatives to non-competes that would still be legal?
Yes, there are actually a number, and I think it's important for employers to start thinking about them now. First, traditional NDAs, non-disclosure agreements, are not touched. In theory, non-solicitation agreements, both as to customers and employees, are untouched. Interestingly, the concept of garden leave was discussed by the FTC, and this means that someone has to give notice before they resign. Typically, you don't see these beyond 60 or 90 days. And I think, reading the FTC literally, that a notice provision, meaning that both the employer and the employee have to give, let's say, 30, 60 days advance notice, means that the employee can be sidelined or placed in the garden on leave for that 30 or 60-day period, provided they get their full pay or benefits. Whether a notice period of longer than 90 days will be enforced is a closer call, and even in states like California, this can be problematic. But I think, given that independent of the FTC, we're seeing states that are already moving to limit or ban the use of non-competes. Look at what's happening in Minnesota just recently, Oklahoma, North Dakota, California. Time-based or milestone-based golden handcuffs can be a practical incentive to retain key people. And this would include retention incentive agreements, phantom equity, restricted stock, giving profits interests under an LTIP, all of which usually contemplate employment through a date certain or are triggered by a change of control event. So if the reward is lucrative enough, the employee will be happy to stick with the golden handcuff arrangement. And that's exactly what businesses in California do, given that they can't use traditional non-competes for employees.
So key takeaways for the final Department of Labor, or for the Department of Labor's final rule on the overtime wage threshold. First, monitor the new regulations. We're going to keep monitoring them ourselves to make sure that we're on top of everything. This should be implemented soon, right? July 1st. Work with your attorney to conduct a privileged audit of your employee classifications internally. Don't forget about the state laws, right? So if the state laws are above the requirements of the federal laws, then you have to comply with the state laws, higher requirements. For example, California and Washington states have much higher thresholds for exempt employee status, over 64,000 for large employers in California and over 65 for large employers in Washington. Those are a few little key takeaways for Department of Labor.
And Andy?
Sure. Monitor the date of the final rules publication, September 18, but watch pending litigation. And I am going to talk, because I teased it earlier in my remarks, about the status of litigation. The FTC rule was no surprise to industry groups. And so there were lawsuits that were prepared, fine-tuned, and ready to go. And indeed, they were filed the day after April 23. 2 cases were filed in Texas, 1 in Pennsylvania. Watch the case that is pending in the Eastern District of Texas in a federal court. This was filed by the U.S. Chamber of Commerce. And this has teed up the big picture policy issues, essentially saying the FTC vastly exceeded its agency authority under what lawyers call the major questions doctrine. And this is the same doctrine that industry groups use to successfully challenge the OSHA COVID vaccine mandate on private employers. As the Supreme Court said, agencies cannot try to stuff elephants into mouse holes. And what they mean is Congress has considered and refused to enact national legislation that would limit the use of non-competes. So why should the FTC stuff this big elephant into the little mouse hole when they're just supposed to create little mice-sized rules that have a more surgical impact on industry? Begin identifying people who are already bound by non-competes, and you still have time. If you have key people who are in states that allow non-competes and they would qualify as senior executives, sign them up now if you want to have a non-compete. And then, of course, work with your legal counsel to make sure you give the right notices if and when the rule takes effect. I personally think that given the litigation that's pending in Texas, that the Supreme Court, as long as it remains or retains its current composition, will invalidate the FTC rule. But that's just speculation, just like I think the Bears will win the Super Bowl in 2025. But that's kind of where I think a lot of lawyers think will happen with the current Supreme Court.
Please contact our speakers directly for any further guidance on either of these issues or any other employment law questions you may have. And just to let the group know, we are already working on the recipe for our next Lunch and Learn, where the topic is going to be reductions in force. So employers who want to know more about the legal ramifications regarding downsizing should definitely attend this session. So watch your inbox and our social media pages for information on how to register for that. and have a great day, everyone.